Hi, good evening, everyone. My name is Rolando Lavaro. I'm the Councilman-At-Large for the City of Jersey City. I think we're going to get started. It's 7:04 p.m. There's a lot of ground to cover, and I know folks have a lot of questions and a lot of information to share, good information and helpful, hopefully. I want to say thank you to our partner, Northeast New Jersey Legal Services, for doing this and bringing their expertise to the table. I think you're all going to get a lot of great information this evening. My office, me and Talita Elizeu, I'm sure many of you were in contact with her directly via email. We heard the concerns about the need and for among renters, particularly in Jersey City, and as well as landlords and homeowners and property taxpayers, about many of the, obviously with COVID-19 sidelining most businesses and most workers and not being able to collect a paycheck. The challenges of getting unemployment claims and any other forms of assistance and having to worry about putting food on the table and paying the rent. And so we wanted to, we're thankful that Northeast New Jersey Legal Services was willing to work with us to present this information. Hopefully you'll get a lot out of it, and it'll be able to assist you in this very trying time that we're, you or your clients, I know many of you are service providers as well. So without further ado, we want to get started. I'm then going to ask that we move to the next slide and then let Northeast New Jersey Legal Services take it from there.
All right, so my name is Gabe. I am one of the attorneys here at Northeast New Jersey Legal Services in the Housing Department. This is Councilman Lavaro's information. So his contact information, I'm sure I don't want to speak for the councilman, but feel free to reach out to his office. I don't know if we can make it to the next slide. All right, so welcome. My name is Gabe. I'm an attorney here at Northeast New Jersey Legal Services in the Housing Department. I will be making this presentation here with Lynn Wang, who's another attorney here in the Housing Department. So tonight we're focusing on issues related to the COVID-19 outbreak, recent developments in the law, relief for tenants who are struggling to pay rent, and your rights as tenants. Some of the information that are contained in our slides are helpful in not just this situation, but other tenancy situations. So we've included them here for your informational purposes. But in the interest of time and focusing on the ongoing crisis, we'll be focusing our attention on the crisis and how it affects tenants. Now, I'm sure we're all looking at the same slide, so we see a disclaimer. And when you're working with a law firm, you're going to see a lot of disclaimers. So this presentation is for informational purposes and is directed at tenants. By viewing this presentation, you're not creating an attorney-client relationship with our office, but we do want to educate you on your rights as tenants and oftentimes homeowners. Now, if you go to landlord-tenant court, you may retain an attorney, but you shouldn't expect an attorney to represent you unless you have an agreement with them. Our office has limitations on who we can represent, such as certain income limitations, and we cannot represent each potential client who qualifies, but we try to provide the best legal services that we can. We ask that you do not reproduce this presentation in slides without the consent of our office. And again, I just want to remind that this presentation is being recorded, and we hope that this is an educational experience that you all can enjoy. We encourage you to ask questions, but we cannot address individual questions specific to your own tenancy. It's best to discuss your individual situation with an attorney. So before you ask a question, remember that this presentation is public and being recorded, whereas your conversation with an attorney can be private in other settings. So let's go to the next slide here. Eric, I don't know if everyone is using this slide. Okay, so who are we? Northeast New Jersey Legal Services is a nonprofit organization with attorneys and staff members who want to connect with the low-income community and communities who've been traditionally underserved by the legal field. We hope to provide legal advice and representation to those who might not otherwise be able to afford it. Our organization specifically focuses on clients in Hudson, Bergen, and Passaic counties. But we have affiliates in other counties in New Jersey. Now we focus on civil law, and our areas of representation are listed on this slide. Eric, I don't know if you can take me to the next slide, because last time I did it, it went to the, all right. So for questions, you can please put those in the Zoom chat or text your questions to our phone number where we're receiving them at, which is on the screen. And for those listening, it's 201-754-8684. Again, we hope to be able to address all of your individual questions, but each person's factual situation is different. And if you're facing eviction, the same broad advice might not apply to everybody. All right, so this is sort of the general structure of our presentation, the topics of slides. I'll be focusing on the latest relief and possible upcoming relief at the beginning of this presentation. Then later, you'll hear from Lynn Wang, who's another attorney in the Housing Department, who will educate you as your right as tenants. All right, so the first thing we're going to talk about is COVID-19, the latest concerns and legislation. On the federal side, we have the CARES Act, and the CARES Act, while a lot of bills are passed in the New Jersey state legislature, the federal government passed the CARES Act, which provides some relief to tenants in federally backed housing. Now, it's important to note that this only applies generally to tenants of federally backed housing. It put a moratorium on evictions for non-payment cases for 120 days, starting on March 27, 2020. In this time, attorney's fees and late fees cannot be assessed. In addition, there is a foreclosure moratorium and other relief that can be given to landlords and homeowners where their mortgage is federally backed. However, the best strategy for taking advantage of this relief for homeowners depends on this landlord's individual situation. Now, right now, landlords who've received a break on their mortgages under the CARES Act are not technically required to pass those along to tenants, unless, of course, except for the federally backed housing, which we just discussed. But there are state bills which aim to sort of take care of that. If we go to the next slide, please. All right, so the first thing, which I'm sure we've all heard about, is Executive Order 106. Now, this is an order, the New Jersey State Legislature passed a law which allowed Governor Murphy to issue an executive order putting a moratorium on evictions during the state of emergency and up to 2 months thereafter. Now, this order specifically states that any lessee, tenant, homeowner, or any other person shall not be removed from a residential property as the result of an eviction or foreclosure proceeding. Now, this means that the enforcement of a warrant of removal and judgment of possession are stayed until when Governor Murphy declares the state of emergency over or up to 2 months thereafter. The legislator may further empower the governor to declare more relief, which is in bills that are being discussed in the legislature. Now, these include more direct relief to tenants, and these are bills that I will be discussing shortly. Now, some of the questions that we've been receiving is your rent still due? Now, this order specifically addresses that and states that this does not affect scheduled rent as it becomes due. This does not stop your rent from accruing. All this does is that it prevents you from being evicted. Now, in New Jersey, as something Lynn will discuss later, the landlord can't simply come around and change the locks because you're not paying rent. Only the court can do that, because these warrants of removal, which is the notice that you would get before the eviction would happen, are no longer being acted upon. There are no more removals, and so these evictions are stayed. So we don't want to say that all evictions are stayed. Evictions can still technically happen, but the standard for these evictions is that these evictions happen in the interest of justice. Now, this is an unfortunate nebulous standard, but we do not believe that simply not paying rent is a reason to evict under the standard. The goal and public policy here is that we want to prevent evictions during this crisis. Governor Murphy has also made a declaration regarding security deposits and back rent. Now, this is something that Lynn will be covering in greater detail later on in the presentation when she discusses the security deposits. If we can go to the next slide, please. All right, so as I discussed, this does not affect scheduled rent as it becomes due. Now, this excludes, this order excludes hotels, motels, guest houses, or seasonal tenants and facilities. If we go to the next slide, please. But this has the protections to many of these tenants has been extended in a new administrative order, which is very recent. It protects residents of hotels and motels who have nowhere to safely and lawfully return to, as long as they're not considered transient or seasonal guests. Now, this is important, because many people who are staying in long-term hotels and motels, have no other residence. And so this administrative order extends the protection of Executive Order 106 to those tenants. If we can really please move to the next slide. So court closures. Right now, the courts are closed through May 31st, 2020. We do not expect the court to be conducting many eviction hearings electronically. As Lynn will explain, the landlord cannot resort to self-help to evict you. This can only be done by a court officer through court process. This means that if your eviction has not commenced, it likely will not commence until after this date. Also, we are expecting a potential backlog of cases. This means that there could be a delay in evictions, but it is important that tenants don't rely on a backlog of cases in the hopes that they don't get evicted or their eviction is sort of indefinitely postponed. I like to prefer a proactive approach to eviction where appropriate. Something where you can work with your landlords, and these are things that we'd be happy to answer questions about and discuss further. Go to the next slide, please. So what we're going to be talking about now are the bills that are pending in the state legislature. So right now, the relief for tenants is largely just not being evicted, and what Lynn is going to discuss with security deposits. Many of these bills that we're going to discuss connects the relief that landlords are receiving to relief to tenants. Now, these bills that I'm going to be discussing are not law yet, but if they are passed by the legislature and signed by the governor, they will become law. However, as of right now, these are bills in the pipeline, but not yet law, and they may not become law. So this particular bill, Bill S-2340, this is pending legislation that, if passed by the legislature and signed by the governor, would allow the governor to issue another executive order consistent with the act. This would provide emergency relief for building owners on the condition that they in turn provide that emergency relief to impacted tenant. So the building owner would be receiving relief, and then the tenants would then be notified and would be allowed to apply to the landlords for relief. Now the landlords in turn for receiving this relief would have to provide relief to the tenants. Violations of the landlord of that act can be considered a violation of the New Jersey Consumer Fraud Act. Now this, of course, we would need to see what the executive order announced after that bill, if passed, would look like. So if the landlords accept this relief, they must in turn provide relief to tenants. Now, there are some relief that could be provided to tenants regardless of whether or not the landlord accepts the benefits of the bill, such as restricting late fees and preventing some evictions. If we go to the next slide, please. So Bill S, this bill is not quite as exciting. This bill simply limits rent increases based on inflation. Landlords could still seek higher rent increases, but would need permission to do so. Whereas of right now, some landlords have a little bit more leeway in how much they can raise the rent. Certain cases are controlled by rent control, certain cases by other standards, but this would very much narrow how much landlords can raise rent. Now, importantly, this bill doesn't provide a whole lot of relief for tenants who are, currently unable to pay their current rent. If we could move to the next slide, please. So this bill also stays the enforcement of eviction orders, but it also stops the initiation of eviction proceedings. This bill provides relief for landlords in granting a forbearance on mortgages, and it prevents all rent increases during the crisis. This relief can last up to 6 months after the end of the state of emergency. Now, we've been hearing this phrase lately in the news, the phrase rent freeze. The official statement of this bill mentions a rent freeze, but it's unclear if that means that tenants wouldn't have to pay rent or if it means that there's a freeze on the increase in rent. From the text of this bill, it appears to me that the freeze is only on rent increases. If we can move to the next slide, please. So this bill, I guess I would like to call the big money bill. This bill would provide up to $100 million in relief for tenants facing the crisis. This would be entitled the 2020 New Jersey Emergency Rental Assistance Program and would be administered by the Department of Community Affairs. This program provides relief to tenants who cannot make rental payments for reasons beyond their control and due to the COVID-19 crisis. Now, it's important to note that from looking at this bill, if you are able to pay your rent and are simply want to rely on this law to pay your rent for you, that might not be available. And by administering this program, the administrating office would verify with the landlord that there is a rent owed and then pay that rent directly to the landlord. The landlords would be required to cooperate with the inquiry related to this law. There would be income limits on this money as it's tailored to medium and low income tenants. Landlords would be paid again directly from the program, and tenants would be given a copy of that payment. Now, this is important because if the landlord receives that money from the government in lieu of back rent, they can't just turn around and take the tenant to court for non-payment of rent. If we could go to the next slide, please. So one thing I wanted to bring up is government-assisted rent programs. Now, the programs that I'll be discussing are those where your rent is tied to your income. So that your rent is either a portion of your income. If your income goes up, your rent goes up. If your income goes down, the rent goes down. So right now, obviously, a ton of people have seen their income plummeted. It's been very difficult out there. So if you're a recipient of these benefits, such as Section 8 benefits, where your rent is tied to your income, it's very important to let your housing authority know they've suffered a decrease in income due to the COVID-19 crisis. Now, this can be done with an interim recertification. HUD has somewhat alleviated what is needed for an interim recertification, and it's important to do this so that, as we discussed, you still have an obligation to pay, your rent and what would be your portion of the rent. This way, your portion of the rent doesn't accumulate so much. By doing an interim recertification, you could potentially lower your portion of the rent, and therefore you're not looking at a large stack of arrears, which may be difficult to overcome if certain prospective relief isn't passed. And so we're going to go to the next slide, please. And now we're going to turn it over to the councilman for his remarks on what's happening locally. Thank you so much for letting me speak.
Thank you, Gabriel. Hi, everyone. Thank you, Gabriel. Okay, get my slide back. There you go. So I just wanted to touch on a couple of things, and then other folks will and then they'll return to Northeast New Jersey Legal Service will return to continue their presentation. A few things here locally that I want to talk about. The first thing is a rent freeze. Right now, before the City Council, there are two pieces of legislation that the City Council will be considering for adoption on Wednesday, May 6th. One rent freeze ordinance was introduced by the mayor and the administration. That applies to during the course of the state of emergency. Will allow for rent freezes for any rent-controlled units, 5 units or more, that are rent-controlled, and not all units are that are 5 units or more are rent-controlled. But for those, there'll be a rent freeze for those units. And then Councilman Solomon, and which I support, he introduced initially legislation that would put a rent freeze on all units throughout Jersey City, whether 4 units or less and 5 units or more. It would apply to everyone. That was originally introduced. It was amended for 4 units or less to only be applicable to non-owner occupied units. A couple of council people had expressed some reservations about the rent freeze, and of course that rent freeze is also applicable during the course of the state of emergency that the city and the state would be in. And so as a concession, in order to get that introduced so that there would be a similar rent freeze for 4 units or less, it would exempted properties that were owner occupied, where meaning the owner of the building was actually living in the property itself. So that would commonly be something like a 2-family home where maybe the owner was living in one of the units and had a tenant in the second unit. So that would be exempt from a rent freeze. And then the other concession that was made on that was that it would expire, instead of for the length of the state of emergency, it would expire on August 30th. And we would, if the state of emergency should continue beyond that, then we would have to re-up the legislation in that event. So that's the rent freeze. And what I just wanted to urge folks, obviously I'm in favor of the one with Councilman Solomon, as I said earlier, on Wednesday, May 6th. There is a public hearing on it, and urge folks to come on out and join us again on, it's not a Zoom call, but there's an opportunity to be able to participate and let your voices be heard with regard to those two different competing legislations. The second thing I wanted to talk about is that there's legislation at the state level. The last time I checked, and I'll be honest, I didn't get the most recent update at this point, but there was a $100 million rental assistance bill that was introduced. And I know that the senator represents Jersey City as well as Union City and Hoboken, was instrumental, Senator Brian Stack, in moving that forward. That would provide some sort of rental assistance to residents throughout the state of New Jersey, and allocate $100 million in that form. I am looking at that bill more closely, and then I'm not sure exactly the specifications, but I do know I'm going to support it, because that's, as far as I know, the only bill that's out there that's providing some form of actual rental assistance and relief, direct relief to renters at this point. So, and I say that very confidently, just because I know that 70% of our city, as I've said, may have said at the beginning, of Jersey City's residents and households are renters, and approximately 30% or more are cost burdened pre-COVID, meaning that they had to, I think it's larger than that, maybe it's 40%. Toledo would be able to get me that number more precisely, but a large number of residents in Jersey City who are renters are cost burdened, meaning they spend more than 30% of their income on rent. And so you can imagine post-COVID, when no income or maybe no job, that number's going to go up dramatically. And then lastly, the city has established a Jersey City COVID-19 Relief Fund. There's been a fundraising push in that regard, and to date, at least $3 million have been raised. It seems like a lot of money, but in fact, it's not a whole lot because it's not necessarily designated for anything in particular. So we've got small business concerns, we have homeowner and property tax concerns, and we have renter concerns. And so for my part, I'm going to be urging, since we haven't determined necessarily where the funds will be allocated, I'm going to be urging that the mayor and my colleagues in the council consider putting it into allocating substantial amounts of that money towards rental relief and rental assistance. And that's administered while it's been raised through by the city of Jersey City, and the mayor's made a big push around it. It's being administered through a autonomous agency called the Jersey City Economic Development Corporation. So to a certain extent, while I can advocate for it, it's outside of my legislative authority to be able to actually determine how funds are there, or even to make proposals that have to be considered. I can just simply advocate. As soon as we have more information about that, we'll share more of that information as well. And so with that, I guess I'll turn back over to the host and see where we're going from here.
Okay, thank you, Councilman. This is Eric Hughes with Northeast New Jersey Legal Services. So as you can see on the slide up here, these are some links, for additional information on COVID-19 information and updates. This, as a heads up, we will be sharing this presentation in PDF format with all the hyperlinks after the fact. So, don't worry about trying to get all these links down right now. We will share that after this presentation. So there's that. And if you have any questions regarding, possible court cases that you have with in Hudson County, on the screen is the information for the Hudson County courts. Again, it's a lot of information to take down all at once. We will be sharing this presentation, so this information will be in your inbox in the next day or two. Moving right along, because we want to be mindful of your schedule. If you have any questions, we're trying to answer them in the chat. You can also make use of the texting option, 201-754-8684. Again, for those who may be calling in, you can text in your questions to area code 201-754-8684. And I will turn it over to my housing colleagues to get into some of the nitty-gritty on New Jersey tenancy and eviction law.
Great. Thank you, Eric, and thank you, Councilman Lavaro, for putting this together. So I'm just going to be going over some very basic eviction protections, as well as some strategies that you might use regarding your security deposits and paying the rent. So first, the New Jersey Anti-Eviction Act is the primary basis for many of these evictions. And I believe right. So as Gabe mentioned earlier, there are no self-help evictions. This means that you cannot be locked out of your apartment by your landlord. It has to be done by a court officer. The landlord cannot take your belongings out. They can't shut off your utilities, etc. If you're, unless you have some sort of court order. And even in that case, it has to be done by a court officer. And if we can go to the next slide. Oh. Oh dear. I think, okay. Okay, so just to reiterate, for those who might be tuning in, there's some frequently asked questions, whether or not you still have to pay, you do still have to pay rent during COVID-19. The arrears may continue to accrue, but a lot of landlords are being flexible and may set up payment plans. If you're not able to pay rent, the landlord can file an eviction action against you. However, as Gabe discussed earlier, there are some protections that have been enacted or are in the process of working their way through the legislature. And as we also discussed earlier, there are a lot of eviction cases right now, and so there's probably going to be a significant backlog that will delay the hearing of any eviction action against you. So if we could, all right. Okay, so next slide. Okay, so first I'm just going to talk about eviction protections. If we can go to the next slide. So, as I said again, no self-help evictions. If you are facing an illegal eviction, if your landlord has locked you out, then you should call the police, and you should also consult an attorney. And if you get some sort of complaint in the mail regarding an eviction action, we also strongly advise you to consult an attorney. But if you have found that you've been locked out, the first thing that we recommend is going to the police so that you can get back into your apartment. And then seeking legal recourse. Next slide, please. Okay, so I'm just going to be briefly discussing the Anti-Eviction Act, which requires good cause to evict. This means that you cannot be evicted for anything other than these reasons that are specifically enumerated in the Act. Next slide. So some exceptions to the Anti-Eviction Act. The Anti-Eviction Act applies to most landlords, but there are certain properties or tenancies that are exempted. For example, 3-unit owner-occupied premises. So if you live in a house that has 3 units or less with your landlord, if it's a duplex and your landlord lives there, then the Anti-Eviction Act may not apply to you. Also, commercial tenancies. So, for example, if you have a shop, if you're living in a hotel or motel, or if you're not a tenant, if you're staying temporarily at someone's apartment for a week or two or something, then the Anti-Eviction Act would not apply to you. Can we go to the next slide? Okay, and as we had discussed earlier, EO 106 suspended evictions until May 19th or until the public health emergency is over, whichever is later. So by evictions, I mean specifically a the court officer cannot come to your house to physically lock you out of your home until the earliest date is May 19th. But if the governor renews the public health emergency declaration, which I believe has currently been renewed for May 9th, if he renews it again, then that date will be pushed. And there's also language in the order that says that evictions are suspended until no later than 2 months after the state of emergency. So, this is sort of a gray area where it's not certain when exactly evictions would start back up after the state of emergency. It could be up to 2 months afterwards, where there is a moratorium on evictions and they are not being performed. And as Gabe discussed earlier, the administrative order extends the executive order's protections against evictions to individuals who are living in a hotel or motel and don't have permanent housing or are not able to safely seek permanent housing. Next slide, please. Okay, so as I discussed earlier, you have to have good cause for eviction. The landlord can't just decide, I don't really like having you here, so I'm going to evict you. You have to have some sort of reason that is in the act. The most frequent or the most common kind of cause of action is generally non-payment of rent, but there are other causes of action. For example, if you're paying rent late habitually, if you're disorderly, if you've breached the rules, or for criminal conduct. Next slide. And other good causes might be that if you're living in an illegal apartment, but you would then be entitled to relocation assistance, which means that you should receive you should receive 6 months worth of rent as relocation expenses prior to leaving the apartment. Other good causes is condo conversion, personal occupancy, or if your tenancy was conditioned on employment. So for example, if you were a superintendent and you started your job and moved in, at the same time that you began your tenancy. Next slide, please. So for many of these actions, you need to have notice of the action. So for non-payment cases, New Jersey law does not require that you receive notice. However, if you are living in a federally subsidized or project-based or Section 8 voucher programs, you do have to get some sort of notice about non-payment. But typically for a non-payment, it's kind of assumed that you know that the amount of that's not been paid. But for other causes, you do have to receive notice. And so the first thing that you should receive is a notice to cease. And a notice to cease is basically a written warning that is telling you, stop this conduct and advising you that, if you continue, then it could give rise to an eviction. Now, there are very specific rules about the notice to cease. It can't be that the first time you do something, the landlord gives you a notice to cease. They have to be able to show that this has been going on before it has issued and continued in between the time for the notice to quit. And you must also give you enough time to fix the issue. So next slide. Now, after receiving the notice to cease, you should receive what's called a notice to quit. This is another warning. It's essentially a second warning that is telling you that, you were warned about this conduct and you did not cease it. And therefore, this is letting you know that the landlord is now going to file an eviction action. And again, there are very specific requirements for the notice to cease. And there are many defenses, and you should definitely, consult with an attorney regarding those defenses because they can be very fact specific. But some examples would be if no notice was given. So if you weren't aware of any sort of conduct, if you weren't given a notice to cease, or if the notice was not specific, it just said you were being disorderly, for example, and doesn't tell you, what exactly it was that you were doing that needed to stop. Other times there's the wrong notice period, if it wasn't given to you, with enough time to allow you to cure, etc. Or if the landlord has accepted your rent after giving you the notice to cease, then that might be considered a waiver. Next slide, please. And this is just, a brief overview of some of the many defenses to eviction. Specifically regarding non-payment of rent cases, if you pay your rent by 4:30 on the court date, if you pay your rent on the court date, then that case should be dismissed. Other times, if your rent was paid and you know that it was paid, you can show that the rent was paid. Definitely keep receipts of all of the times that you have paid your rent, via money order, bank account statements. We strongly recommend that you don't pay in cash, but if you do pay in cash, you should know that as of December 2019, the landlord is required to give you a rent receipt for any payments that are made in cash. And that if they don't, then that can be a valid defense to a non-payment case. And there are other defenses to eviction that we won't focus on today because we're primarily focusing on COVID. But all of this information will be in the slides that are sent out to you. Next slide, please. Now, one of the new reliefs that has been passed by the bill, that has been passed recently by the legislature, allows for you to pay your rent even after a lockout has issued. So, just briefly kind of going over the timeline of a case. If a non-payment case has been filed against you, you should receive a complaint and you'll receive a court date. On that court date, you can pay your rent. If you're not able to pay the full amount of your rent, then a default judgment will likely be entered, and then the landlord will apply for something called a warrant of removal. Now, the warrant of removal will be posted on your door, and it will let you know when your lockout is. And with the passage of this new bill, up to 3 days after your lockout, you are able to pay the full amount of rent that is due and owing, and the landlord is required to accept it. And the case should be dismissed with prejudice. Now, the rent may include late fees or attorney's fees and court costs. We definitely recommend that you look over your lease to see if there's any provision that says that late fees, attorney's fees, etc., should be considered additional rent, because if that is the case, you may have to pay that rent. You may have to pay that kind of money in addition to the regular rent that you're paying. Next slide. And so rent control, at least within Jersey City, for older buildings that are, this is basically if the building was constructed before 1983, and there are 5 or more apartments, that building should be subject to rent control. We definitely recommend that you check with the local rent control office, their number it is posted here, to see if your apartment is subject to rent control. It might be the case that you are paying more than is legally allowed, and that is definitely a defense to non-payment. A lot of times you may end up with a rent credit if you have been overpaying. Next slide. So now I'm going to talk about security deposits. So under the Security Deposit Act, if you pay a deposit to a landlord, he has to deposit that into either a bank account or a money fund if they have more than 10 rental units. And that bank account should be paying some sort of interest. Next slide. So once you give that security deposit to the landlord must give you written notice about where that security deposit is. So the name and address of the bank, the type of account, the current interest rate, and how much you paid into the security deposit. Next slide. Now, this has to be provided within 30 days of receiving the deposit. Other instances, if the deposit was moved or if the owner sold, the property and it's being transferred to a new landlord. And every year, there is interest that should be accruing, and you are also supposed to be provided written notification of how much interest that is. Next. Right, so this, if the landlord did not comply with this act, so for example, if the landlord failed to put your security deposit into a bank account, or if they fail to give you notice about where that security deposit is held, you are entitled by law to apply that security deposit to your rent at a rate of 7% interest. So, for every year that your security deposit was in a bank, was supposed to be deposited in a bank, and you either weren't notified about that, or the landlord just didn't place it in the bank at all, you can take that security deposit, apply 7% interest and use that towards your rent. So this is essentially a punitive measure. The legislature really didn't want landlords to just, be holding on to security deposits without properly putting them in the bank and ensuring that tenants know, where the security deposit is. And so after you apply the security deposit, you are not required to replace that security deposit. And this would apply to buildings that are covered by the Anti-Eviction Act. So again, buildings that I discussed earlier, if you're living in an owner-occupied unit that has 3 units or less, that would not necessarily apply, but you can opt in to the Security Deposit Act by giving written notification to your landlord that you would like them to start complying. But you would have to give them, 30 days to be able to do so. Next. Now, some other guidelines: the maximum amount of security deposit that you can pay is 1.5 times the monthly rent. They can't seek any additional funds on top of that. For example, if they're seeking a pet deposit, then that would be considered, again, part of the security deposit. And you cannot pay more than 1.5 times the monthly rent. That 1.5 times the monthly rent is based on the amount of rent that you owed when you moved in. And if they, if the rent increases and they're trying to get more rent out of you, then they can only request 10% more of the current security deposit as an additional security. Next slide. So the security deposit interest. So just to clarify, if the landlord has put your security deposit into a bank account, you will probably be receiving about 1 to 2%, maybe even less interest on that. The 7% figure comes from the law, which the 7% is only applied if the landlord does not comply with the act. If, for example, if they don't tell you where the bank account is, or if they just don't put your security deposit in a bank at all. Now, but if they did comply, the security deposit interest, you should be receiving some sort of interest on the security deposit. It could be variable. It would depend sort of on, the details of your account, but that interest should either be paid to you in cash, or it can be credited towards your rent every time the lease is on the anniversary of the lease or on January 31st. Now, if they don't provide interest, or they don't provide the annual interest to you, then you must first let the landlord know in writing that they have failed to provide the interest and give them 30 days to cure. Now, regarding the return, after you vacate an apartment, you are entitled to the return of the security deposit. Now, they can deduct charges, for example, rent, unpaid rent, or damages. They can't deduct for ordinary wear or tear, but if you had a remaining balance of rent and you vacated the apartment, they are entitled to deduct from the security deposit. I think that's sort of the point of the security deposit, is to allow the landlord to have some sort of recourse for damages or unpaid rent. But if the security deposit was wrongfully withheld, if you didn't know any rent, or if you didn't damage the apartment, then you can sue the landlord for double the security deposit, and you can sue it for the amount that was wrongfully withheld. And you can do that in small claims court, which in the cap on small claims court is for about $5,000. So Executive Order 128, this is very recently passed. The governor just issued this order and it allows tenants to apply their security deposit to their rent including, the portion of the interest that they were supposed to be getting with the bank account. So that would be, again, the less than 2% interest. This request must be made in writing, and the landlord can still recover money from it that would be taken from the security deposit. So for example, damage to the apartment. Now with this order, it does require that tenants replenish the security deposit within either 6 months after the state of emergency is over, or within 6 months of renewing the lease, whichever is later. So, if you're, you may be able to apply the security deposit to your rent, but if you're not going to be able to provide the security deposit, or provide the amount of the security deposit within 6 months, then it may not be advisable to do so, because you would just still be on the hook later for that security deposit money. Next slide. So I just wanted to kind of briefly cover those two strategies regarding a security deposit. The first one for the statutory relief, which is the 7% application of the security deposit. This is only if your landlord has not complied. So if your landlord did not give you notice, if the landlord did not put it in a bank account, then that's the only time that you would be able to apply the 7% plus your security deposit to your rent. So we would also recommend that you look at your lease, because a lot of landlords do put their the bank information in their lease. That is considered adequate notice. But one thing that you can do is you can ask the landlord to provide you information about your security deposit, because even if they provide you notice, if they never put your security deposit in the bank, that's not compliance. But if your landlord has complied, if you receive everything, if you get a letter every year about your annual interest, all of that, Executive Order 128 still gives you the option of applying your security deposit to your rent. And this is with the applicable interest. It's not going to be 7%. It will be however much the bank account is giving you, and you will also have to replenish the security deposit later. Whereas, with the first approach, if your landlord isn't complying, then you don't have to replenish the security deposit. So we would definitely recommend that you first see if your landlord has complied, because, we think that the exposure is, and the application might be better. But, if your landlord has, then you still are able to take advantage of this executive order to apply. But you should just know that you might be on the hook for the security deposit later if you renew the lease, or up to 6 months after the state of emergency is over. And if you have any questions, or if you are concerned about specific issues, then we would also recommend that you reach out to us, reach out to an attorney to discuss the specifics of your situation. Thanks. Okay, so I'm just going to briefly cover, the right to safe and decent housing. There is something called the warranty of habitability, which, under New Jersey law, and I think many places elsewhere, the apartment or the place that you're residing must be maintained in a safe and decent condition. This is, all things that are just important for, regular living. So, for example, heat, if you have broken windows, etc., security. Next slide. And, landlords of buildings with 3 or more units have to keep their building up to code, and that's enforced by the DCA and the town inspectors. Smaller buildings are still subject to local ordinances. And this is just a brief overview of the heat requirements. If your apartment does not have heat, these are the codes that your apartment should be complying with. And these are a list. This is a list of resources in Jersey City, phone lines and hotlines that you can call if you believe that your apartment is not in compliance with any of these codes, or if there are issues that are interfering with the habitability of the apartment. Now, if you are residing in an apartment and there have been issues with the apartment that are interfering with your enjoyment of the apartment, you can withhold the rent. And the way that you should do that is you should send a written letter to the landlord, keep a copy of it so that you know exactly what you told him, and the date that you sent it, detailing kind of the issues with the apartment. Give the landlord a reasonable time to make the repairs. And if the repairs are still not made, you can withhold the rent. Now, it is very important that you withhold the rent, but don't spend it. Put it in a money order, put it in an envelope, put it under your bed or something, because if the landlord files a non-payment case against you and you don't have that money, you can still be evicted, even if you are withholding it for repairs. Because if the landlord files a non-payment case against you and you go to court, you will be required to pay that money into court. And after the repairs have been completed, then that money gets released to the landlord. So it's very important that if you decide to withhold the rent, that you don't spend it. You can also do something called repair and deduct. Essentially, that's essentially what it sounds like. You repair it yourself, or you can hire somebody else to repair it, keep the receipts, and deduct that from your rent. Next slide. And just a brief overview of renter's insurance. Just be aware that if things in your apartment are damaged, you may not be protected, and so renter's insurance can help cover the cost of damage or theft, or if your apartment is unlivable and you need to stay in a hotel, then it can cover those expenses. Okay. And there are a lot of resources out there that we are sharing. These are the different homelessness prevention funds that we recommend calling if you need help. And all of this will, again, still be in the slides that we send out. Okay, and we'll be taking questions. And again, the number to text if you have questions is 201-754-8684.
Great, thank you, Lynn. I just wanted to address some things I saw. I've been reading the chat here with some of the Zoom questions. I just wanted to sort of address maybe two concepts. So one, I've seen questions about tenants who are living in buildings with less than 3 units. And I'm not sure looking at these questions if they're owner occupied, but evictions in general are stayed, not just evictions that are covered under the Anti-Eviction Act. No matter, in most circumstances, you can only be evicted by a court officer. And right now, those evictions are stayed. And so in a general sense, you shouldn't worry about a court officer coming to evict you because you're likely covered by Executive Order 106, or as extended under the Administrative Order 2020-9. And so I've also seen some questions about some sort of specific situations about, what to do as far as, if you moved out or partial, paying partial rent, sort of general advice. And again, everybody's situation is different. And so this advice, would have to be, if you want more advice about your particular situation, you need to speak with it'd be good to speak with an attorney. And, there are some people that we can help with our income restrictions and our guidelines. But if you're looking at maybe paying partial rent, then, if you want that to count as, let's say April 2020 rent, it would be advantageous to communicate with your landlord. And let's say, if your rent is, I'm just going to make up a number, $1,000 a month. If you could pay just $500, you might want to make sure that $500 counts as satisfaction of that rent in full. So that way you're not just going to be on the hook for that money for later, because otherwise you could have saved that $500 and potentially just paid that in court. Otherwise, you could be, putting good money after lost money. But everybody's situation is particularly, different. And so this is why it's important to, discuss with counsel, think about your options and strategize. For the security deposit law, you would need to renew your security deposit either when you renew the lease or within 6 months of the end of the declaration of the state of emergency, whichever comes later. That's my understanding of that law. As far as applying the, these protections to, I guess I saw a question about, families living in motels. Is a little less clear. It appears that this law would apply to, families and individuals staying in hotels and motels as long as they don't have somewhere they can, safely and legally return to. This is, again, a very sort of fact-specific situation. So, you would need to look at the facts of everybody's individual case to determine if you fall under that law. And thank you. Please feel free to keep submitting more questions. Eric, if anybody has texted in any questions, please feel free to raise them so that way we can address them.
Yes, absolutely. Thank you, Gabe and Lynn, for that presentation. We're trying to be mindful of the questions coming in the text, and I know it can be a little frustrating. You may want to just unmute yourself and ask your question. We want to be mindful that if you do have a question, to avoid sharing any personal or confidential information, just because first and foremost, this is a public presentation, it's being recorded, and we don't want your information to be captured. And for the umpteen thousand people who may watch this later in the future, at least that's what our egos tell us. How many people are going to watch this? They may have access to that. So certainly feel free to text those to 201-754-8684, or you can put them in the chat box. Also, the last slide I'm going to move to here in a second will be Northeast New Jersey Legal Services contact information. Actually, I will go ahead and do that now just so it's up there for everyone. And actually, I was going to address one question. It looks like Larry, our managing attorney of the housing unit, is addressing some questions in chat. Again, if you have a question, feel free to put that in the chat box. Or if it's something that may involve you needing our services at Northeast New Jersey Legal Services, on the screen right now, contact information for our 3 offices. We serve Bergen, Hudson, and Passaic County. We're accessible via phone and email right now. Our physical offices are closed, but we are currently serving clients and new applicants remotely. So there's the email address, our website, our social media. Please, please, please feel free to reach out to us. We are here. We're your community-based, lawyers, neighbors, so we thank you for, being with us today. Councilman Chalita, did you have any additional comments, anything you'd like to add before we maybe get close to wrapping up?
No, just thank everybody for coming. And feel free to send any more questions you guys have. We'll do our best to connect you to NNJLS, or whatever we can answer, we will answer. Thanks for coming.
Great. We answered all the questions, Eric? Everything was?
I think so. I'm watching the chat right now, and I know Larry Sindoni, our managing attorney of the housing unit, has been responding. We actually just had one come through. Can the landlord use the security deposit even if the tenant hasn't requested they do so?
So I can manage that. The tenant would need to make that request to the landlord, and I would, I would encourage people to do that in writing, such that you can be sure that your landlord, has received that. And so, oftentimes, as Lynn had discussed, sending letters to your landlord via certified mail, any sort of mechanism where you can communicate with your landlord such that you can be sure that your landlord has received it, I find is beneficial. We sort of assume everybody, is an honest and good-natured individual, but, by sending things certified mail and via email, you can be sure, that they've received it, because, a lot of times you just want to be sure, not only what you know, but what you can prove. And so by sending things via certified mail, that's hopefully something that you can prove. It makes it a little bit easier. And as far as I saw a few questions on there about rent control apartments and condos. So that a lot of times those rent controlled apartments depend on when the building was built. And so, we would just need to see, your individual situation to tell you whether or not your particular building is rent controlled, because there are some exceptions there.
And just to piggyback off of what Gabe was saying about security deposits, if you don't request that your security deposit be applied, the landlord cannot, of their own volition, apply it. So, the landlord can only deduct things from your security deposit for damage or rent that is owed, but that is after you move out of the apartment.
Yep. And to, looking at Leia's question here, There are, I guess I'm not totally sure what you mean by tenants in good standing, but there are, part of the Anti-Eviction Act, this is something we didn't necessarily cover too in depth because we were focusing on COVID, is there are some exceptions if the landlord sells the building and then, the buyer either needs to deliver it vacant or, in certain cases, if the landlord is going to be moving into your particular unit, there are some exceptions there. But as of right now for COVID, these evictions are stayed. So my advice to tenants are to be first focus on your health. And in general, if you believe you're facing eviction during this crisis, it's critical to participate in the court process and, if possible, contact counsel for legal advice.
I just wanted to add a few thoughts as I saw some of the questions scrolling across. With regard to if you're wondering if your building is rent controlled, if you live in Jersey City, we can help you with that in our office. If you reach out to us offline and give us your information, and we can check the records there to see and check with our Office of Housing Preservation to see if they can determine for us whether that's a rent controlled property or not. And I think I saw something a lot earlier about the rent freezes and whether or not certain buildings in downtown. And I think it depends on what we pass ultimately on Wednesday, May 6th, and what we see as and what it'll apply to as a rent freeze. So I'm not sure which building, but if was that if you email us offline, we can look into your particular property and then see what ultimately what gets passed there on May 6th and see if it's applicable to you as well. Were there any other questions at this point?
I just wanted to address a little bit of the security deposit questions. So the tenants that are covered by the executive order are also, regarding security deposit, are also going to be tenants who are covered by the Anti-Eviction Act. So if you're living in an owner-occupied unit that is 3 units or less, then it is unlikely that the executive order would apply to you unless you opt in to the Security Deposit Act, which means that you would have to send a written request to your landlord, give them 30 days to comply, and then go from there. And again, regarding that specific issue, we would definitely recommend that you contact our office or contact an attorney so that you can get more specific advice regarding your situation. And the second question that I wanted to answer is regarding replenishment. If your landlord has failed to comply with the Security Deposit Act, you don't have to replenish your security deposit. So again, if they fail to comply by not putting your security deposit into a bank account, if they fail to comply by not giving you notice of where that bank account is, what that security deposit, its interest is, etc., you can apply your security deposit with 7% interest and not have to replenish it. This is essentially to punish the landlord for not complying with the Security Deposit Act. Now, if your landlord has complied, if you can still apply your security deposit under the governor's order. But again, because the landlord has complied, this is really just to allow you to pay your rent, but it is expected that you will be repaying that security deposit either 6 months after you renew the lease or 6 months after the end of the emergency, whichever is later. So you should expect that, if you do renew the lease or if you're still staying in that apartment 6 months after the expiration of the emergency, you will have to replenish that security deposit.
Okay. Is there anything else out there?
Yes, there are just 2 more questions. I'm not sure if it's been answered. Folks asked about if a tenant passes and there are other people that, in the apartment living there who are not listed on the lease, what options do they have? And then we've got also a question here about landlords with mortgage forbearance and whether or not they are legally obligated to also pass this on the relief onto their tenants.
Yeah, so as far as, if the tenant on the lease passes away and there are still occupants of the apartment, that can be a very complicated situation, and that's something that, would very much depend on people's individual factual situation. As of right now, I would imagine that those occupants are still protected by the executive order and cannot be forced out. from my perspective, from what I've seen, a lot of landlords simply just want to be paid rent. And so if you are, if the person on the lease has passed away and people are living there, if you're able to keep paying rent, I don't particularly see a reason why the landlord wouldn't be amicable to, allowing the occupants to stay there, unless, of course, there are some facts that simply we just don't know about. And then, as far as whether or not I see a question here about, if landlords must provide the, breaks that they're getting to the tenants under the CARES Act. The answer, unfortunately, is not really, unless, of course, you're a covered tenant by, if you're like a Section 8 tenant, then you get some relief. But it's the state laws that are in the pipeline, which we discussed, which, if passed, would connect that relief to the tenants.
I see a couple of other questions coming through. Did we address that?
Yeah, so a tenant in court, this is in response to the question about proof, which they have complied with the security deposit. So from my experience, the landlord will generally have to prove that they have complied with the Security Deposit Act. They're the one who has the information. And, oftentimes that can be done if they show up to court and they either have the lease, which says, here is where the security deposit is being held and I've given adequate notice, or the letter, that I sent to the tenant. Oftentimes this can be done, this will turn into kind of a factual battle in court, where the tenant will be asserting that the landlord didn't comply, the landlord will be asserting that they did comply. And so in this case, both parties would simply just make their case in front of the judge, and the judge would have to make a determination whether or not the judge believed, the question of fact, did the landlord comply or did the landlord not comply? And so, this is, like a tenant could ask for proof that they have complied. I would just submit something in writing to the landlord, like an email or a certified letter. That way you can track it, and just ask for confirmation of the security deposit consistent with the Security Deposit Act.
More messages coming in. You covered all that, Gabriel?
So there are some of these questions. I see one from a Laura about, I guess the Order 128 that applying, most tenants to apply their security. I think that's something that Lynn discussed. If you are covered by the Security Deposit Act, that would be something that you could apply that security. And to answer, I guess, that follow-up question, if you have to go to court to find out if the landlord complied, that would mean that, there's a difference here. You could apply the security deposit under the executive order, which then you'd be applying it without that 7% interest. But if you are sure that your landlord did not comply with the Security Deposit Act, and then you go to court, you can assert the security deposit defense, which would then apply the security deposit plus the 7% penalty interest. So that would be more defense that you assert in court.
Right. So, and just to piggyback off of that, you can first send that letter saying, you have failed to comply. I'm going to apply my security deposit with 7% interest. This is how much it is, et cetera, et cetera. And I do believe I saw a question earlier that was asking when that applies. It starts from the day that you get that deposit. So if you moved in 2013, that interest accrues, assuming, again, that your landlord did not comply. And if the landlord refuses to apply the security deposit, then once you go to court, you take out that letter and you say, this is my defense. And at that point, the landlord, if the landlord has evidence, the landlord should present that evidence that, he put it into a bank account and that there's this letter that has your address on it that, was sent certified mail or something that shows that you did receive notice. So, you would still be able to assert that defense. You can assert it prior, but, if the landlord refuses to apply it, then you can go to court and you can still assert that defense.
And to answer Frank's question there, that would be something that we would, if you qualify for our services, I'd like to talk to you about. There are some, prospective reliefs. It's hard to address that without knowing exactly what your, situation is. But sort of in the abstract, there is action that could be done. But first, the thing you want to do is sort of confirm, what the rent control amount is. And then, these are just some sort of like factual findings and investigation that, you would do in conjunction with your attorney before any action was filed. But, if your landlord is charging you what is above, what is allowable based on rent control, that could be a potentially actionable issue. But again, everything, needs to be sort of, with, if you would like, further clarity, these are things that you want to discuss with an attorney beforehand.
So somebody just forwarded me this question. I just posted it regarding folks who have tested positive for COVID-19 have been in a hospital. Is there any special kind of protection?
Not that I'm aware of for people who have specifically those, or for specifically those who have tested positive for COVID-19. Maybe that's something that the council might be able to shed some light on, if there's any maybe funds or public funds that are being given to people who have actually tested positive for for COVID-19. As far as like earmarked funds in bills that I've seen that are going to directly people who have tested positive for COVID-19, that's not something that I personally am aware of yet, but that doesn't mean it doesn't exist. It just is, that's a pretty maybe niche issue that maybe hasn't come across me yet.
I'm not aware of anything myself at this time, but certainly can look into that. And was there one other, Toledo, or that's it?
I think there's one that came through basically, so you have to go to court first to find out, actually the correction just came through, the most recent one in the chat. Can a tenant ask the landlord for proof they complied prior to any court filings and trying to settle the rent owed issue?
Certainly. So you can definitely ask the landlord for proofs, or a lot of times what we have here, we have a letter, in which case we give tenants, where instead of asking for proof, if you're sure that they didn't comply, just tell them that you would like to apply the rent plus 7% interest to the rent owed, to the rent due. And then if they have proof, they'll likely come forward with it. And so, that's something that, that's a frequent situation, in which we advise tenants on. And so you can ask your landlord for proof, but then you're perhaps possibly adding a step to that, to that situation, which you might not ordinarily have to go through. Now, the defense would be, if the landlord then takes you to court, you then assert that defense in front of the judge, and the judge would make that finding whether or not the landlord actually complied. If the landlord, of course, is contesting.
And I think there was just a comment, posted in the chat saying there are housing discrimination protections under state law for COVID positive tenants. They can reach out to fair housing agencies or the New Jersey Division on Civil Rights. Do you know anything about that?
So that is something that I haven't really come across as of yet. I think the question that I saw as with respect to the COVID-19 tenancies was about more economic hardship. Like if you had perhaps COVID-19 and therefore you were unable to then pay your rent because you're out of work because of that illness. So as far as economic relief, that's not something that I've seen, but there are, I would need to look into this or these housing discrimination policies to see how much they would cover as opposed to for economic issues as opposed to sort of otherwise discrimination as we sort of ordinarily think it.
Regarding the 7% interest for the security deposit, it is 7% interest accrued annually for each year that the landlord did not comply with the security deposit.
And that 10% is, if they, want to increase your security deposit because of an increase in rent, that's where that 10% comes in. If your security deposit, let's say, is $1,000, and then they want you to add another $1,000 to your security deposit, that's well over that 10%. And so that's not something, that is something that you would have a defense on.
Okay. Are we ready to wrap this up, or where are we?
It looks like, sorry, there may be a little feedback. I think there aren't any more questions. And again, if you did put a question in the chat box and we somehow missed it, I do apologize about that. Please feel free to reach out to the councilman's office or Northeast New Jersey Legal Services. Again, keeping in mind that, we may not be able to address specific personal situations, but again, the councilman's office as, as the representative at large, Councilman-At-Large, would encourage you to reach out to him, and they can certainly facilitate getting those questions to us. So again, I would recommend you reach out to his office or us. The contact information for Northeast New Jersey Legal Services is up on the screen. And I think there was also a question. We're going to be emailing this presentation out in PDF format and maybe also some other materials as well. So if you didn't capture all of the information, I know there was quite a lot. Don't worry, we're going to send that out soon. And always thank you so much for your participation, your patience and flexibility. And, that does it for Northeast New Jersey Legal Services.
I'll just say thank you to everyone for attending tonight. I do want to just acknowledge, I noticed that we had the director, I'm not sure if she's still out there, the executive director for the Jersey City Housing Authority. Thank you for joining us. And we also had a representative from Councilman Solomon's office, which I mentioned that Sarah Ligon was with us on the webinar, and Councilman Solomon sponsored that rent freeze legislation that hopefully we're going to adopt on Wednesday. I'm sorry, not tomorrow, but next week, Wednesday, May 6th. And just say thank you to everyone. I want to say thank you to Northeast New Jersey Legal Services. Can we all give them a big round of applause and thank you.
Too kind.
A couple of final thoughts from me, which is just that these are incredibly difficult times right now for all of us, and we keep seeing the hashtag "We're in this together." And so, if you're having rental challenges, and I think most tenants want to pay their rent, and if there's economic challenges that they're having, they certainly do want to pay it. I think in most cases, and certainly there are some bad apples out there, but if they don't have the resources, I think if tenants reach out to their landlords, and most landlords are willing to work with folks, I think in most cases can probably work something out and figure out how everyone can get through this together. And lastly, just kind of saying that as we talked to, as Northeast New Jersey Legal Services talked about all of the rights and responsibilities at the end of all of this, when hopefully this pandemic and this virus fades away, we'll still have our responsibility to pay rents, even if there's eviction freezes and things of that nature. So don't let that kind of accumulate on you. And so thank you again to Northeast New Jersey Legal Services. I'll shout out to Eric, Gabriel, Lynn, and Lawrence. And then if I missed anyone from your team, I apologize. And you did a great job and appreciate it very much. Thank you, everyone.